All rise. We will be. Please be seated. We
are in open session, Your Honors.
Thank you very much. Mr. Nurtete, please.
Thank you, Thank you very much, Mr. President, Your Honors. This is the first time the Victims' Counsel expressing his views on this litigation. First of all, Your Honor, we support the prosecution's application for the inclusion of 80 items in the prosecution list of evidence. In our view, the prosecution's application raises two questions. One is procedural, the other is substantive one. Firstly, the procedural one, which is the time limit in our observation. In our view, Your Honors, the prosecution's arguments in support of the extension of the time limit for the inclusion of the items in the list of evidence are sufficient. So, therefore, we will not add anything else on what the prosecution counsel already had put forward in writing. Your Honor, the next issue is a more complicated one, which is the substantive issue, in our opinion. This issue is whether the prosecution may use those items. If Your Honor's minded to grant the prosecution request, whether the prosecution can use those items in order to show the Chamber the alleged interference of prosecution witnesses. Your Honor, before going into the matter, we note that parties generally agree that the prosecution may use those items in order to confront those witnesses. But what the parties do not agree is what extent the prosecution may use those items in order to expose certain acts of witness interference. Your Honor, in our respective submission, the prosecution should be allowed to certain leeways to use those items in order to show you the alleged acts of witness interference and the impact of those interference on the credibility of the testimony which these witnesses will bring. Your Honor, this, of course, corruptly influencing witnesses, of course, in a serious crime under the Rome Statute. Your Honor, proving the commission of those crimes, the offenses against administrative justice, is, of course, a separate issue, which should be subject to an independent proceedings. But, however, Your Honor, the prosecution had already pledged that the use of those materials, the prosecution will not use those materials in order to show any form of guilt on part of the accused persons. Therefore, Your Honor, in our respective submission, there will be no prejudice towards defense if prosecution use those items in the purpose they seek to introduce. Your Honor, we also note that the prosecution seeks to introduce those items in order to assist the Chamber in making an informed determination about the credibility of the certain summoned witnesses, in particular, the real reasons behind their recantation of their previous testimony. Your Honor, in our view, the credibility of those witnesses, in particular, the question of why those witnesses had recanted their testimony, and, Your Honor, the issue of alleged acts of interference, those two issues, in our opinion, are intrinsically connected. Therefore, we say that these are they are these two sides of the same coin. Your Honor, we submit that there cannot be full and proper and objective assessment of the evidence that these witnesses are going to provide. Without engaging this inquiry as to the circumstances of their withdrawal from the process and the circumstances that forced them to recant their testimony. Your Honor, we submit that by only allowing the prosecution to do this, the Kennedy Court be able to see the whole picture and find the truth. Your Honor, I will conclude shortly. Your Honor, in our view, overriding objective of this trial process is to deliver justice not only to the parties, but also to the victims as well. Justice and truth are inseparable, and justice cannot be done without establishment of the truth at first. Your Honor, it's noteworthy that Defense Counsel has reiterated previously that they want witnesses to come and tell the truth. In our submission, defense cannot now disavow their appeal and shy away from introduction of this evidence, which will assist Your Honors to find the truth in properly assessing the credibility of those witnesses summoned. Your Honor, in conclusion, we submit that the whole truth must be known, including the circumstances which forced those witnesses to recant their testimony. And we submit that the admission of this evidence in question and the use by the prosecution for that limited purpose would be a step towards to that goal, which is establishment of that truth. Yeah. Thank you.
Thank you, Mr. Narasatsing. Mr. Khan, you were rising to address before I invited Mr. Narasatsing. Of course, your first point of call would be that you do not oppose using the material as such, but you have some difficulties as to the extent of it. Isn't that your point?
Indeed it is, Mr. President, and that's the nub of our response to the prosecution application. And I'll deal with that in a little more detail. We do rest generally upon our submissions, which are, in our respectful submission, detailed and set out our position adequately in relation to the prosecution original application. But at the outset, it's only right to address certain points that have been raised today. We do not cavil at all from my learned friend for the legal representative of the victim's assertion that justice and truth are inseparable. That has been our assertion from the outset. There is, of course, a difference between the parties, the prosecution and the legal representative for the victims, once again on the same side, and the defence as to what that means. But the prosecution has repeatedly said, look at the big picture. What is the big picture? The big picture is that 3.5 years ago, Mr. William Ruto had his good name sullied with a summons that was announced as a Christmas present by Luis Marinho Ocampo. The truth is that a year ago this month, a trial started. The truth is 21 witnesses have been brought voluntarily by the prosecution and have had their accounts tested. The truth is that not one victim witness has testified to seeing weapons, and yet the prosecution stubbornly cling to a narrative and seek to summon witnesses that assert 3,000 weapons are given. It must be the first time in history 3,000 weapons are given to youths and not a shot fired according to the prosecution's own evidence, and not one youth seen with a weapon according to the prosecution's own evidence. But, Your Honour, going to the...
Mr. Khan, it may be advisable at this stage not to make closing submissions on the evidence already heard. Let's just deal with the matter before us. Because the prosecution, once you open that gate, assuming we allow the gate to be opened for all to walk in, the prosecution may feel it is right that they also comment on the evidence heard so far. So let's not go there. And let's focus on the material before us.
Your Honour, I will do that, and I will be so advised. And just for explanation, in my submission, the big picture is important, because it is my vigorous submission, and I've said it before. The prosecution realise that this case is going to fail. And I'm asking the court to consider very seriously my submission that what is motivating the prosecution, unfortunately, is not a search for the truth, but having an exit strategy. So when this case is dismissed, or when not guilty verdicts are entered, they will say everything was to order. The case was confirmed, and their imperative at the moment, and let there be no pretense about it, they want there to be a defence case. That's their imperative. Because whenever there's a defence case, in the event Your Honours side with the defence and say there's no case to answer, or, that the case is not proved, the prosecutor, and I can see it, even without a crystal ball, she will say this is justice. There's a not guilty verdict. Judges, we are vindicated as the prosecution because we put a case forward, it was confirmed, we put a case forward and the judges said there's a case to answer. And so the fact that 4 or 5 years of somebody's life have been in turmoil is really a price worth paying. Long live justice. That is the end game of the prosecution. It's creating a narrative now that will excuse their massive systemic failing. And, Your Honours, what has the game plan been? Let's expose it, because it is the big picture. They have said this is about obstruction. Well, yesterday we heard 4 out of the 5 summonses have been served by the Republic of Kenya, the Attorney General of whom has graced this court on at least 2 occasions. So the obstruction argument is revealed in its naked truth as nothing other than hot air devoid of merit. What are they left with? The same old narrative that is going out to the public, to the people of Kenya, that yes, they actually have a case. They've done their job. They have the right man. But bad defence or bad third parties, it's all down to witness intimidation. And that's the narrative that they're seeking to push. Your Honour, my learned friend has said he's cognizant of Miss Cynthia Tai then leading this case, her undertaking, that she did not wish the prosecution, the prosecutor, because it's a unitary office, would not seek to use evidence of consciousness of guilt. Despite being allegedly cognizant of that, it is in our respectful submission revealing, to say the least, that there was not an iota, not a word of mention of that undertaking in the prosecution's original filing 1463.
Mr. Steinberg has again, prompted by me to address the matter, has also said that he is mindful of what his predecessor in the case had said. I believe Ms. Tai at the time said it was not the intention of the prosecution to argue, make arguments of consciousness of guilt and the manner of witness interference. Mr. Steinberg has said today that at the moment they're not intending still to do that, but then if they do want to make any such case, they will let us know, and you will be given an opportunity to speak to the matter.
In my respectful submission, Your Honour, that's not good enough. It's getting very close to an abuse of process by the prosecution to renege upon undertakings. And Your Honour, we set out in our response the undertaking of Cynthia Tai, 1 sentence of it. But Your Honours will have, of course, in due course, look at the transcript. And I jumped up at least twice, said, I'm not clear what is the prosecution doing. And lo and behold, a year later, they are seeking, for whatever words, to do precisely that. Because, Your Honour, contrary to the undertaking of Mr. Steinberg, contrary to that undertaking, and it's revealing, in this case, they filed an application. They've been given leave to reply. And then they filed an addendum. A last throw of a dice, we say, in this case. But, Your Honour, let's look at it. In paragraph 33 of their own filing, which they did not refer to at all in their reply or in their addendum, what do they say? They say this at paragraph 33. The prosecution will argue, no uncertainty, the prosecution will argue at the relevant time that the fact that the existence of a conspiracy to corruptly induce prosecution witnesses to withdraw or recant, if accepted, is a factor that supports the veracity of the original evidence implicating the accused. What on earth is that, if not consciousness of guilt? And the prosecution, in their reply, seek to take issue with our assertion.
Is it the same thing, really, if doesn't consciousness of guilt stand on its own, in the sense that, yes, an accused person has been, there's evidence clearly showing that an accused person has been engaged in a certain kind of conduct. Because the accused person has engaged in that conduct, judges, we want you to infer from that what motivated that conduct was consciousness of the guilt of the accused person. is it the same as saying, well, the witness had given a testimony at some point? Sorry, statement to the prosecution at some point, and had subsequently disavowed that statement, and the prosecution is saying, judges, we want you to inquire into how that disavowal came about. If you agree with us that the disavowal was improperly procured, then we will urge you to disregard the disavowal that the witness gave on the stand and accept what they said the first time in a statement. Is that the same thing as consciousness of guilt?
Well, Your Honour, in my respectful submission, the prosecution application, reply and addendum is characterised by an attempt to be ambiguous on core issues where they're in difficulty. Because once again today, and it's in support of paragraph 33, what did my learned friend Mr. Steinberg say when he was on his feet? At page 15 he said, and one can refer to it verbatim, but my note was, it's hardly likely that somebody will spend the time and energy to track down witnesses who are complete liars. Your Honour, again, lawyers are, my learned friend is a very clever man, he's a senior counsel, the prosecution is full of brilliant minds, and of course lawyers can pass words and divide words and give connotations that they want. But what was the nature of the undertaking given by Miss Cynthia Tai in May 2013, when I was given leave to stand up twice and press home the point? It was very clear in our submission that we did not want this nonsense, and we say it's patent nonsense. It's a smokescreen to pollute this case of witness intimidation. And, Your Honour, we went so far, and again it's pertinent to the bona fides of the prosecution application. We went so far as to say, and it was an application originally, I think, of Mr. Sang, that Article 70 allegations could be dealt with as a preliminary issue. Now, the prosecution were opposed to that. One wonders why. Was it because that their witnesses would be discredited before the case even started? And, Your Honour, why were we doing it? We were doing it because we, and I use these words at some stage, we want to know what the target is. We didn't. We've been blindsided. My learned friend sent an email that over the summer recess there's an amnesty. So we said, okay, we'll agree to that. We will not have filings. There was no courtesy filing. A few days before this session, we are ambushed, we say, ambushed by a new application for the first time stating that they were seeking to add evidence as incriminatory evidence. And the prosecution averments that somehow there's no prejudice, and that being repeated by the legal representative of the victim doesn't make it the truth. There is massive, obvious, clear prejudice. What is it? The prosecution say, well, this has been disclosed previously. That's a half-truth. Because firstly, it was withheld from the defence. It was only unredacted the day before the filing, on the 21st of August, I believe. Some of it, important aspects of it, were unredacted on the 21st of August. But, Your Honour, we cannot swim against the tide. We are a small defence team against the power of the prosecution, supported by an assembly of state parties, having all the cooperation of states, including the state of Kenya and other states. We have a right, any accused has a right to know what the target is. And the fact evidence has been disclosed does not give me as lead counsel an obligation to run around like a headless chicken, chasing my tail to find out and ferret out what could possibly be raised. I will focus my energy. I will use the money and the resources provided to me by my client to focus on the allegations raised by the prosecution. And the prosecution did not add this evidence to its list of evidence. They did not say, this is going to be used to incriminate you. And they went so further. When I gave them a chance, what are your intentions? Look at the substance, look at the spirit, look at what Miss Cynthia Tai was saying. She said, no intention to use it for consciousness of guilt. That would be a distraction. We agree, strangely, perhaps for the first time, with what my learned friend Miss Cynthia Tai had to say. It would be a distraction, it is a distraction, and it is massively prejudicial to the defence. Your Honour, we also asked...
Mr. Before you proceed, still on Miss Cynthia Tai's what she said on the record. She said that before the commencement of this case over a year ago, that she said that Mr. Steinberg this morning expressly said circumstances have changed. Does that mean anything, or ought it mean anything? Let me be specific. Let's say at the time, I would take a hypothetical case, an example, and not so that we don't frighten people in this case. Let's assume this was another case, and Ms. Cynthia Tyler, the prosecutor, before the commencement of the case, said there had been witnesses interference. We want to bring forth some evidence of that. And the defense said, no, you shouldn't. And the question arose, Ms. Ty, are you doing this for consciousness of guilt? And Ms. Ty said, well, on the basis of what we have now, no. And later, or even doesn't say on the basis of what we have now, no, but simply said no. But events evolved. Subsequent to that, events evolved. And let's say, and again I want to be clear, because we don't have evidence in this case that the accused person is directly implicated in any witness interference. If the prosecution has that case, they will have to make it before us. But let's assume that evidence emerged that in that other case I'm talking about, example, evidence emerged that the accused person may have in fact been implicated. That was subsequent evidence. Would the undertaking given before still bind in that sort of situation?
Well, Your Honour, this is all broadcast publicly, so I will say, for fairness to Mr. Ruto, even on the prosecution evidence, there's no direct allegation at all that Mr. Ruto has done anything untoward. And that needs to be emphasised, because what is happening in this trial, and the way the prosecution has chosen to conduct it, is that a person presumed innocent is being maligned continuously by a narrative, and the reality is not being properly focused. And Your Honour, the other aspect I'd ask the court to bear in mind very acutely is we are at peril, and a reference was made to the victims, we are at peril of losing sight of justice, and losing sight of the interest of the victims, and losing sight of what this case is about, the post-election violence of 2007 and 2008, and going on a wild goose chase on the runaway train that the prosecution would have the bench embark upon to an unknown destination, but that is miles away from the truth. And so we, in the strongest possible way, say that that should not be allowed. Your Honour, in regard to the hypotheticals, I'm not going to pin myself down at the moment, but I will say this. The further one goes into a trial, the more onerous is the responsibility to show good cause and necessity even. And otherwise, the right of an accused to have an expeditious trial is going to be a dead letter. And Your Honour, unfortunately, and I've said it before, and tragically I have to say it again, certain aspects, certain rights that are given to the accused are being rendered a dead letter by this Office of the Prosecution. And I'll give you one example. In relation to witness 16, my learned friend from Mr. Sang, he's recanted. He was interviewed abroad with an international lawyer present, gave a long interview, and Mr. Sang's team contacted the prosecution and said, what are your intentions in relation to witness 16? Because it's important. His account actually is completely, is largely anyway, supportive of what we've been saying from the beginning. What did the prosecution say there to that uncomfortable truth, that reality of witness 16? They said, Article 54, we're going to investigate it. We're going to investigate. Important point, again, I'd ask the bench, or all three of you, to, with the greatest of respect, to hold closely, is the false narrative or the false options presented by the prosecution. That witnesses are presented effectively with two options. You recant, or you stick to your statement. That should not be the focus of testimony, because there may be truths and untruths on both sides. The important focus is a witness telling the truth here before your honours, and let the parties test and challenge and evaluate. And we have said, we're different to Mr. Sang, we've said, Your Honours, this evidence, let it be added to the list of evidence for the sole purpose of being a reservoir available to the prosecution, that if that scenario is reached, that a witness is declared hostile, and if the court say a witness is not desirous of telling the truth, the court may allow the prosecution upon application to use certain evidence and to exhibit it. And we've done that, Your Honour, because we are not scared of the truth. I am not scared of the truth in this case. But what I have great trepidation about, what I am not sanguine about, is the due process rights of Mr. Ruto, because I fear that we are being sent on a maze adventure into which we will spend an awful lot of time going to a closed door at the end. It is unnecessary to raise these issues. And in assessing...
Isn't your point, Mr. Can, simply this? Doesn't it boil down to this? That if those documents are going to be used for the exclusive purpose of confronting the witness about any disavowal of statement, you have no difficulty with that. But if the objective is to bring in that big picture of a generalized witness intimidation scheme, it is a generalized picture that has a bearing on the trial of your client for the purpose of answering the question guilty or not guilty of the crimes charged. Therefore, that big picture may create prejudice to your client, whether or not it was intended so by the prosecution. Is that your case?
Your Honour, largely it's correct that we have stated that it can be used in our submission. We're not opposing evidence. We're not opposing a witness being tested. We're not opposing a witness being challenged. We are not opposed to the truth coming out. We're in favour of all of that. What we're saying is the prosecution assertions that this can be used to show general prejudicial evidence that the defence has not investigated, that we're not able to challenge, is massively and grossly prejudicial. Your Honour, the prosecution have said in their filing that this is the tip of the iceberg and that they are going to make other applications for other witnesses. We're deluged, in fact, just before the new session with these applications, the new documents, to analyse it and look into it and decide what strategy to approach and how it can implicate on us. And, Your Honour, if the prosecution application is allowed, it's going to require a significant months of delay for me to start investigating a collateral case. And from the beginning, I think it was one of the phrases used, the shadow case. And we were told that that shadow case would not be presented. And it seems, no, it's not a shadow case. That shadow case is becoming the main case, and we're losing sight of the PEV case. And that's my concern. Your Honour, the prosecution assertions, and it's been repeated a long time, and I've left it alone because I thought it was quite straightforward and it was premature. But once again, they say there's an ancillary purpose to all of this because it could be relevant to a Rule 68 application. Your Honour, in our submission, that's a bad point. In fact, it's a point even made in bad faith, because apart from the provisions of Article 51(4), the prosecutor was present in the Assembly of State Parties when that rule change was made. She's invited, we're not. But, Your Honours, one can look at the verbatim record and look at the material states put in. There were clear averments made by State Party members that rule change would not affect ongoing trials. And so the prosecution know that, and yet their last throw of the dice again, another option. Put the statements in. Why? Put the statements in, defence don't challenge, it means there's a case to answer, let the justice be done, let Mr. Ruto be acquitted in 2 years' time, and the institutions, not the institution, the prosecution's failings will be given a fig leaf by the judges. And that is our very serious concern. We have said this case should not have been brought, and we've said it's not rhetoric. It's because the prosecution have failed to investigate. They have failed to look for the truth. They've looked away from the truth in their interviews. When it comes to witnesses that are like witness 16, they're investigating. When it comes to other witnesses, they want to declare them hostile and put in all kind of other evidence. We say, yes, let them. Let them test their witnesses, because, Your Honours, these witnesses, 336, Mr. Baraza, were prosecution witnesses. They were prosecution intermediaries. The prosecution gave them benefits, not the defence. And when these crooked witnesses went further bad, when these individuals started telling the truth, or at least in part, that's a matter to be assessed. Maybe they're not. But when they went away from the script, the untruths, the prosecution say, well, somehow it's nefarious. Your Honour, it may be nefarious because they have not exercised judgment and caution and diligence in assessing who are witnesses of truth at the beginning. And that's why we're in this lamentable situation. The checks and balances that office was mandated to apply were not put in force, so they didn't investigate properly their own witnesses. They didn't check verifying facts. They didn't do the basics, and they're saying non-cooperation. Does that excuse not even asking certain basic questions? And that's why now the whole story's moved away. Poor victims. Poor Mr. Ruto. On this odyssey of the prosecutor to justify a case that should never have been brought by opening up a completely new case that does erode into the Article 70 jurisdiction of the pre-trial chamber. Your Honour, it's a very sad day, it's a very worrying day, we say, because I'm not sanguine about the intentions here. When one is looking at significant events, the approach to witness 16, the refusing when I asked the deputy prosecutor to investigate one of their witnesses, just investigate for Article 70, the refusal to even consider when Ms. Dato Alagendra and myself met him, even to refuse receiving our information for the purposes of an investigation. They said, no, leave it till the end. Why? Why should the show go on? It's as if the prosecution say it's a bad movie. It's a terrible movie. We didn't pay to see this. But we must sit in through to the end, however painful it is. We can't have our own exit strategy. The judges should be forced to have a defence case, and this is the method by which the prosecution are achieving it. Your Honour, if the prosecution application is granted, it will require significant adjournment, significant expense, significant resources to investigate and test something that we say is false. The prosecution have a bad track record. Let's not beat about the bush. They got it wrong from Mr. Koski, they got it wrong from Mr. Ali, they got it wrong from Mr. Mathara, and they're saying, no, Your Honours, this time, fourth time lucky, we get it right. Your Honours need to be cautious about their protestations of certainty. They've got this case wrong. We say that the primary application, to use it for these ancillary purposes, should be rejected, and we'd urge you to grant, at most, what the defence for Mr. Ruto put forward. What we hoped was a balanced and fair, in fact, bending over backwards to be fair to the prosecution approach, so that the witness can be tested for a limited purpose, and it will not necessitate this wild goose chase that the prosecution would have us embark upon. Your Honours, I'm grateful, and those are my submissions.
Thank you, Mr. Khan. Mr. Katwa. First things, Mr. Katwa, it looks like your written matter was filed out of time, wasn't it the case?
Yes, Mr. President, I propose to address that issue. Mr. President, may I start first of all by saying that I have reconsidered the filing I did on behalf of Mr. Sang. And I now take the position that we do not oppose, I do not oppose the use of the materials for purposes of challenging the witness if he has been found to be hostile. Your Honor, we will of course on our part expect that a determination is made immediately before that material is used that he has been deemed and found to be hostile. Your Honor, we are aware that our filing number 1407.
But you know, of course, don't you, that there is a difference between placing the materials on the list of the prosecution document, which largely serves notice purposes to you, versus actual use of any of those items when the time comes. We know that, don't we?
I do, Your Honor. Your Honor, just so that we are clear, we are saying we are not opposing to the inclusion of the list for purposes of the prosecutions in case they intend to use. We appreciate the difference, Your Honor. Your Honor, we would also like to indicate that on our part, we've raised in our filing that we have a certain concern, and we pray that in determining this issue, or even in the course of trial, that consciousness be placed on the issue as to whether the use of those materials could prejudice the interest of third parties to whom those materials make reference to. The prosecution in the argument have said that their desire is to present to the court the bigger picture, and the prosecutor has used the word mosaic picture. And much as we do not object to the inclusion of the materials to the list of items, we are concerned that in the course of it and in the process of trial, there is a possibility that third parties could be mentioned or affected or prejudiced in the event subsequent proceedings are conducted against them, particularly under Article 70. Your Honor, two last things I wish to mention. I propose to be very brief. Two last things I wish to mention. Your Honor, we are alive to the fact that we made our filing at 4 o'clock, our application number 1407. Your Honor, we were supposed to have filed that by midday, by 12 o'clock. Your Honor, we pray for the exercise of your discretion to admit our filing out of time in view of that oversight on our part. By way of explanation as to why that happened, Your Honor, it was simply an oversight on our part to notice that the time within which the filing should have been done was midday as opposed to 4 o'clock. And so, to that extent, Your Honor, we very much pray for exercise of your discretion to admit our filing. The last issue I wish to make reference to, Your Honor, is the matter that has been made, that Mr. Khan has made reference to, and that is the issue of witness number 16. Your Honor, it is indeed true that we wrote to the prosecution on the 25th of July 2014, 25th of August 2014, and the prosecution responded shortly thereafter. And in our inquiry, Your Honor, we highlighted the fact that the witness number 16 had very specifically said that most of what he had said in his original statements were untrue and that they were product of his own inventions. And we asked two important questions to the prosecution. The first one is what they intend to do with the fact that that witness had indicated that what he had initially said was not true. And the second one is what they propose to do with him in respect to his status as a witness. Yeah, Your Honor, the prosecution, the third issue we raised, Your Honor, is that witness number 16, unlike all the witnesses we are waiting for, was willing to come and testify, Your Honor. The prosecution in their response, Your Honor, said that in view of their interest in investigating both incriminatory and exculpatory evidence, they are conducting investigations on what they refer to as newly evolving issues, and that they will come back to us, and that they intend to call him in the next session. Now, Your Honor, we submit that it is very telling that in coming before you and in justifying their intention to include these documents in their list of documents, the prosecution have said they are interested in giving you the bigger picture. Your Honor, in fairness, if they were honestly interested in giving the bigger picture, we submit, have expected them to include the presentations and the observations made by witness number 16. And witness number 16 has said exactly what we've always said, particularly in regard to Mr. Sang. He says, the question is put very directly to him whether he has been influenced or not. And he says he was not influenced. Further questions are put to him as to whether his change of position is because of influence. And he asks the prosecution, the first thing I inquire from you is, in my own statement, I have contradicted myself. Did I need to have been compromised to contradict myself in my original statement? One. Number two, if you are diligent, couldn't you have noticed that I have contradicted myself? Couldn't you have asked me to explain my contradiction? Your Honor, that is the extent to which this witness number 16 went. And this witness number 16 is obviously very intelligent. The question is put to him, and this is an...
Mr. King Kato, let's not discuss in further detail what it is that witness 16 said and has not said. In the public session, if you feel it is truly necessary for you to engage in that discussion, we will have to do it in private session. But it's for you to tell us if you consider it truly necessary.
With your permission, Your Honor, I am very much alive to the need for me to be careful not to say anything that is revealing of this witness.
Not just that.
Sorry, Your Honor, that not only that.
Do you really intend, is it critical to your submission to engage in further discussion of what it is witness 16 said?
Only one item, Your Honor, and which in my view I can say in public. Only one item.
We will do that in private session. We'll go into private session now for 2 minutes, within which I hope Mr. King Kato would finish that discussion.
We're in open session, Your Honors.
Thank you. Mr. King Kato, please proceed.
Your Honor, in view of all the things I have said, Your Honor, it is our submission that, first of all, the witnesses or let me put it like this, Your Honor. We have no objection to these items being used, Your Honor. But we would like to raise the flag that, in fact, the prosecution have been selective in the material they have presented to you with a view to giving you a complete picture. The second issue we wish to say, Your Honor, is that the court, and we pray very much that the court remains alive to this, that it is possible, that it is true, that our narrative, that all these allegations against Mr. Sang and Mr. Ruto are false allegations fabricated by some individuals, Your Honor. That's all I wish to say.
Thank you very much, Mr. King Kato. Mrs. Steinberg, any reply?
Briefly on a few discrete points, Your Honours. I'll try to limit myself to the issues at hand here. I observe that my learned friends have rather used a scattergun approach in their responses, and as Your Honour commented, it sounded at some stages as if they were embarking upon their final arguments. But I submit the nub of the issue here is the relevance of this evidence, and I was rather distressed to hear my learned friend from Mr. Ruto describe these as a distraction and, in fact, as nonsense, if I heard correctly.
Correct. Distraction was the word of Miss Cynthia Tai.
Yes, with which I understand my learned friend said he agreed for once, strangely. Be that as it may, just to select one example, on the list of evidence which the prosecution seeks to lead are photographs of an occasion where one of the witnesses, I won't name them in public session, travelled to the protection location of another one of the witnesses and met with that witness for the purpose of conveying a bribe offer and said, why don't you accept this bribe like I did that has been offered by these people? You'll return to Kenya and have a comfortable life. Not only is he photographed, he's recorded in his own voice in an unguarded moment, laying out the basis of the scheme to corrupt not only this witness but other witnesses. Subsequently, when he's confronted with this by prosecution investigators, he admits it. Is this a distraction? Is this not fundamental, Your Honours, to the determination of the credibility of this witness and other witnesses who have been targeted in this manner?
But as I understand the defense, I don't think that they're necessarily opposed to you confronting the witness on the stand with the materials you've indicated. Both of them have said there's no difficulty with you enlisting those items for purposes of confronting a witness on the stand. The question is about the bigger picture you're talking about. If that bigger picture goes beyond the credibility of the particular witness.
Your Honours, there is a principle in this chamber, in this court, that chambers should have the ability to freely assess evidence before them. And I would submit that unless it is absolutely necessary, chambers should refrain from trying to box off evidence and saying, well, we'll close our eyes to this aspect or to that aspect. Having said that, the prosecution does not intend to rely on this evidence to say that this proves that Mr. Ruto or Mr. Sang are guilty. But these are factors which the chamber should be free to take into account in the complex and difficult task which will face Your Honours at the end of this case in weighing the competing evidence which is before the court.
But it's always the case, isn't it, that in any criminal case, it's most criminal cases, the issues are complex, and perhaps it could be for that reason that the concern against prejudice, evidence whose probative value is outweighed by prejudicial effect, is a cardinal principle in a criminal case. Here, the defense counsel are saying you're free to confront the witness with a document. Right. There may be also the broader question as to, well, if you successfully confront the witness with this document, is it necessary to do more than say, because we've shown that this witness cannot be believed on the basis of what they are saying, what they've said in court? Judges, we may urge you to give greater credence to what they had said earlier. Does the bigger picture need to be bigger than that? Particularly when you speak about the pattern of intimidation, a pattern of that's pervasive in the case, and the concern arises if you have not directly linked the accused person, directly or indirectly in a credible way, with any such pattern. At what point do we start worrying that the bigger picture may in fact create prejudicial effects if you have not linked the accused person to it?
Your Honours, I submit that the prejudice is mitigated by the fact that the prosecution does not seek to use it to prove the guilt of the accused. And the chamber, being a chamber of professional judges, will disabuse its mind in the ordinary course of the evidence for that purpose. But speaking in hypotheticals, let's assume that we have a witness who testifies, who is recanted, who now testifies that in fact his original evidence was false. The prosecution relies on this evidence to challenge him and to argue that the chamber should accept his original evidence. The defense may, in the course of their case, call witnesses to testify about the fact that his original version was false and his subsequent version was true. If this evidence is only used for the limited purpose of considering the credibility of the prosecution witness, the bigger picture is lost. We submit that in weighing the competing evidence of the two witnesses, the prosecution witness being his recanted evidence, his original evidence, versus the competing evidence produced by the defense, this issue is a matter which will affect and is relevant to the probabilities and the probative value of the competing evidence. And that is what I'm referring to in the sense of the bigger picture.
That includes more or less a placeholder in case the defense does call evidence that may be considered against that bigger picture you're laying out. Is that what you're saying?
If I understand Your Honour correctly, yes. It's determining where the truth lies on the competing version of who's influencing who and for what purpose. I can't put it better than that. If I may ask to briefly go into private session just to raise for no more than 3 minutes to reply to my learned friend for Mr. Sang's submissions on witness P16.
Private session.
We're in open session, Your Honour.
Mr. President, with your leave, can I make just one point? I didn't make it clear, perhaps. I don't want it to be said that there's any inconsistency in the defence position regarding prejudice, that I'm content to show that we have nothing to fear, so that the Your Honours can assess evidence for the prosecution to be allowed to add certain evidence to its list of evidence, and then if a witness is declared hostile, or Your Honours say the witness is not desirous of telling the truth, the witness can then be confronted by it. And my submission that there'll be massive prejudice regarding the other purposes for which the prosecution wished to lead the evidence. And the reason is simple. I'm not going to focus on that. If the witness, and I'll be quite plain about it, if a witness comes forward and sticks to the original narrative, I will test that narrative. My colleagues, my learned friends Mr. Ruto will test that narrative by evidence. If the witness recants and gives another version which repudiates the prosecution account, I will still stick to the original narrative to show it's false. And so I'm not going to embark upon resources on the Article 70. I'm not going to go there. I want to stick as laser-like as we're able to the PEV allegations. And that's why, Your Honours, in my submission, there's no inconsistency in my submission that it can be added to controvert the witness and for the other purposes. Because if the prosecution were granted leave to tender evidence for these ancillary purposes, of course I have an ethical obligation to investigate and test that evidence in order to investigate and understand that evidence so I can test it. If it's used for credibility, Your Honour, I'm not really largely going to go there. Maybe on one of few issues. If they arise, we may. But the primary strategy is to stick to the allegations of PEV, because we can show that they were absolutely nonsensical to start with. And, Your Honours, if we can satisfy you of that, Your Honours, really the case should finish as soon as possible. Your Honours, can I just say, I won't mention the name, but in relation to the witness that was mentioned in private session, it's only fair to say that when that witness was spoken to by the prosecutor, the witness...
No, the witness wasn't mentioned in private session. He was mentioned in open session, and we went into private session. So
okay.
If we're going to discuss it, we'll go back into private session. Back to private session.
I'm grateful.
We're in open session, Your Honours.
Thank you very much. We've had submissions on the matter of the 80 documents that the prosecution wishes to add to its list of documents. The Chamber will render a ruling on the matter, certainly before the witness takes the stand. But that closes that item of our agenda for the day. Unless there is any other housekeeping matter.
Your Honour, just one matter. Yesterday I made an oral application that VW be ordered to disclose the expenses they have given the witness that appeared by video link. And, Your Honours, my learned friend who's not in court for the victim and witness unit stated that, as I understood it, that their preference was to give it to the judges and leave it for Your Honours to decide. Your Honour, my primary submission stands. I do say as a matter of fairness, that is information that should not be hidden from the defence. It can come to us without in any way jeopardising a witness, because we don't need to know, which hotel or which hospital or whatever, just the expenses that a witness has received, because to a witness's mind, whether it comes from the VW or the OTP, really is immaterial, particularly given the joint OTP registry protocol, and I would ask for that information. It will assist preparation. And Your Honours, if you can bear with me. Your Honours, I'm grateful to my learned friend, Mr. Hooper. That information, of course, it's not binding on Your Honours, but it was disclosed to the defence in the Bemba case, and I'd ask that we be given it, not only because of Bemba, but on its merits. It's justified. I'm grateful.
Mr. Steinberg, any?
Yes, Your Honour. In fact, this is the very matter which was argued and ruled upon by the Chamber in respect of one of the previous witnesses. My understanding, and I haven't got the ruling before me, but my understanding was that the Chamber ruled that in the circumstances that the VW is an independent organ of the court, mandated to ensure that all payments are reasonable and necessary, that the limited forensic value of the disclosure of that evidence compared with the real issues of security that may be at risk, and plus the not insubstantial resources that will be necessary to conduct redactions where necessary, and I speak from experience about that, that the balance was that such materials should not be disclosed. So I'm not sure whether this is an application for reconsideration of that decision, or whether my learned friend seeks to distinguish that decision on the basis of some new factors or different circumstances relating to this witness. My understanding was that yesterday Your Honour's ruling was that this should be the subject of a written filing. Perhaps I was mistaken. Your Honour noted that Mr. Keegan-Cutwer had indicated that he was to put in a written filing and that this should be dealt with together. I haven't prepared to argue this matter, but I'm speaking from memory. As a matter of principle, we would join the VW in opposing the disclosure of this information on the basis that it has very limited forensic value, and that having been paid and made by the VW, the Chamber should be confident in the fact that it was necessary and reasonable payments.
Mr. President, Your Honours, can I just say, I don't think there's an issue of joining VW, because VW yesterday did not oppose the application. They simply proposed a different avenue, that it should come to Your Honours first, and then Your Honours would decide if it comes to us. Your Honours, I'm not asking for even redactions of receipts and the like, just a schedule. I'll take them at their word, a schedule of what they say they've paid a witness. Your Honours, your previous, I don't think reconsideration comes into it, because I don't have the reference to hand, so I speak with a little caution. But my recollection was Your Honour was quite careful to say we're going to deal with this witness by witness on the facts. Now, Your Honours, on this particular case, the prosecution have said in relation to adding various documents that it's relevant as to why they recanted. Your Honours, given what my learned friend for the witness himself said yesterday regarding M-Pesa records and the like, Your Honours, we say it's relevant as to why statements, we say false statements, were given in the first place. So it's relevant to the issues. There's no amount of work to redact. It's a schedule. They should have it as a matter of good practice, how much they've spent on their witnesses. All I want is that the parties be given that. If it has forensic utility, we'll use it. If we won't, we'll use it properly and it won't come forward. But either way, it will not disclose anything that would jeopardize the witness, any locations and all the rest. And so, Your Honours, we say the balance is very much in favour of giving it to us. And it can be dealt with. We've got time. It's a very straightforward matter. I've got nothing more to say in a filing. It's a very straightforward matter. Given the issues the prosecution have raised in relation to recantation, we say it's relevant to the issue of an initial statement that we say is false and untrue. That may or may not be relevant to that issue. We've already raised the issue by the Council has raised the issue of M-Pesa records. It may assist the big picture that my learned friend was so keen about earlier in relation to the credibility or otherwise of the witness that will appear before you, and I say no more than that. It's easily achievable, and it's something the VW could prepare in 24 hours at most.
Mr. Keegan-Cartwright, when are you going to file your papers?
Your Honor, I expect to have filed it by midday tomorrow, Wednesday.
Yes, I remember you mentioning Wednesday. Can you not speed it up and file it today?
It's very unlikely today. Could I say by 9:30 tomorrow morning, Your Honor?
By 9:30 tomorrow
Yes,
morning,
yes.
okay. Yeah, do that. In the meantime, prosecutor, the chamber will recommend that you and Mr. Ken or the defense get together to see if you can come to an agreement on this matter.
Your Honour, in respect to this particular witness, there are circumstances which might permit us to do so. But what the prosecution is concerned about as well is that a schedule, as requested by my learned friend, may present a very misleading picture. If at the end of the day we have a figure, a sum of money that the VW has expended on a witness, and my learned friend stands up and says, oh, look, so many thousands of dollars or so many millions of shillings have been expended on this witness, it creates a misleading impression. This is not money going into the witness's pocket. This is money which is being paid, used to pay for necessary expenses.
But isn't it something you can argue at that point, assuming that if you have the ammunition to contain a misimpression that may be created by any use or arguments that might be made in that regard, you surely can also put your own arguments to right the ship, as it were.
It is possible, but that will mean then going behind those schedules and investigating each and every expense, painstakingly reconstructing what the purposes of those expenses were to demonstrate what we already know, and that is that the VW, as an independent organ, does not waste the court's money. It spends the court's money as it has to do and as it determines reasonably under the supervision of the registrar.
Right. You have flagged now some of the possible misuses. We will not presume that the defense counsel will deliberately misuse information, but get together with the defense counsel and see what agreements may be reached without prejudice to Mr. Keegan-Cartwright's papers being filed. And if at the end of the day Mr. Khan says that's not good enough, then we'll take it from there. All right?
I'm most grateful.
As court pleases.
Any other housekeeping matter? We will be adjourning now, and we will reconvene on Thursday morning at 9:30. We will.
Mr. President, the only other issue, I understand summons have been served for 495, who's the next witness, scheduled to start next week. If we start on...
Sorry, he's scheduled on Friday, in fact.
On Friday? Yeah, Your Honour, on Friday of this week. So, Your Honour, we're going to have a bit of a scheduling issue. I presume it would be better, I assume, I may be wrong, to deal with the witness that appeared today. Could I ask for some, it can be done perhaps by the registry, that inquiries can be made so we don't have delay, that witness, is he appearing alone? Is the witness having a lawyer? If the witness has a lawyer, make sure the list of counsel issues are sorted out. And then we have perhaps a renewed date. Your Honours may consider, given that summonses have been served, that one option is we can interrupt on Friday for a few minutes the testimony of the witness, almost so all parties can relax, so to speak, say this is not, trial will not start, the evidence, the testimony will not start on Friday of this witness, but have it almost for mention, so we can find out what is happening, and then give a new date when the substantive testimony of the next witness will start, and then we can focus, members of the team can focus then on that new start date. That seems to be a practical...
Let's not anticipate the problem before it occurs. That if the VW gets back to us or the registry, and if they report back that, yes, that we have a problem here, or on Friday, sure, then we'll deal with that problem.
I'm grateful. Thank you.
All right. We will adjourn for today, and we reconvene at 9:30 on Thursday.
All rise. We will.